Hi, this is Adam Stofsky with Briefly, and we're here for the next episode of the Inland Counties Legal Services Legal Information video series. Today, I'm excited to be here with Veronica Garcia, who is a housing and eviction lawyer. Hey, Veronica, how are you?
I'm doing well. Thank you, Adam.
So today we're going to talk about how evictions start, which is actually pretty complicated. So I wanted to just ask you, just to kick this off, how does an eviction case in California formally start as like a legal process?
So, one of the first things that tenants should receive from their landlord is an official notice. And there's a few things that a notice consists of. And one of the things that people should be aware of is that this notice has to be given to you in a certain method, right? It can't be emailed to you, it can't be given to you via text. It has to be given to you on a piece of paper and it has to be delivered to you, right? So it can't just be, um, delivered in those informal methods. You should be looking for it posted on your door, look for it in the mail, and you should be given a certain amount of time to perform whatever this notice has in it.
So is this required? Like, can a landlord evict you in any situation without a notice like this?
In California, there's a lot of protections for tenants that I think, unfortunately, a lot of tenants aren't aware of, and a lot of landlords aren't aware of. And landlords cannot just say, "Get out of my house. I don't want you here anymore." They cannot just give you a 24-hour notice, and usually that's illegal. Um, if they do, then chances are you may have a valid lawsuit against them, but that's an issue for a different video. Here we'll talk about some of those things that they have to include in the notice that's required to start an eviction case. And these are in situations when maybe they do have a valid reason for evicting you.
So you mentioned before that there's different kinds of notices. Can you kind of walk us through what the most common notices are?
Right. So some of the most common ones that you're going to see and that tenants may experience are a 3-day notice to pay or quit, a 3-day notice to cure, a 30-day notice, and a 60-day notice. And those are probably going to cover 90% of cases for eviction in California.
Okay, so you mentioned four different kinds, and there was some kind of technical words in there like cure. Can you just go through them one by one and explain what these are?
So a 3-day notice to pay or quit is very, very common. So imagine that you're a tenant who hasn't been able to pay their rent. And if you didn't pay your rent, now expect to get this type of notice. A 3-day pay or quit is going to come pretty soon. And even if you've had conversations with your landlord about the rent being late, the landlord's going to still move forward with giving you this type of notice because if they are considering evicting you, this is the first step that they have to take. And even if you have conversations, one of the things that we recommend is have those in writing. So make sure that you write to your landlord, whether that's an email, text, or an official letter, so that you have proof if things do go to court, showing whatever communication that you did have, and you have something to support that. Now, the 3-day pay or quit is usually for unpaid rent, which is considered a lease violation. So if you have anything else that is a lease violation, you also may get a 3-day cure or quit. And what that means is that whatever you've been doing that may be in violation of your lease, you now have 3 days to cure that violation. And a quick example of this is maybe there's a mess on your patio, and that's a violation of your lease. They're going to give you 3 days to fix that problem.
You can fix the problem, or in the pay or quit, you can pay your back rent, and at that point, is the case sort of essentially over, right? Nothing goes forward after that, right?
That's right. So that's one of the easiest ways to avoid an eviction because, as we mentioned at the beginning, this is sort of the start of an eviction case. And before they get to court, they have to show that you did not do what they asked you to do in the notice. And if you pay, or if you fix that issue that they were saying occurred, then you don't have a case, or they don't have a case, and they can't take it to court. So keep documentation if you do pay, keep documentation if you attempt to pay and they refuse, because that could be something that supports your success in a legal case.
Okay, I've got it. So then you mentioned a 30-day notice. What is that?
So a 30-day notice is most common if they want to terminate a month-to-month tenancy. So this is when somebody's lived there for less than a year. And this is also common if you have an agreement that's maybe just a handshake. You don't have a written lease for over a year and you haven't lived there for over a year. So someone can say, hey, I'd like you out of my property now. I no longer want to rent to you. And they can give you something in writing, says you have 30 days to vacate. And they have that right. But they do have to meet this requirement where they give you notice in writing. And of course, it is their property and they have that choice whether or not they want to continue to rent to you, but they do have to meet their legal obligations. So this type of notice, again, is pretty common. And even if you've been paying your rent.
Okay, so that's the 30-day. Now, the fourth one you mentioned was a 60-day notice. What is this? What kind of evictions is this for?
A 60-day notice is required to terminate a month-to-month tenancy for someone who's lived on the property for over 1 year. And this, again, can happen if you've done everything required. You've been paying your rent, you've been a good tenant, but maybe that landlord no longer wants to rent out their property. Maybe they decided they want to take it off the market. Maybe they decided they want to rent it to a family member. They want to sell it. There's a lot of reasons that they can choose to do this. And sometimes there's some underlying reasons that you feel may be at issue. And that's where it is important to contact us or to speak with another organization or an attorney to determine if you have some arguments against, potentially an unlawful eviction. But the gist of it is that the landlord does have that right to choose whether or not they want to continue renting their property to you.
Okay, just then a couple more questions before we conclude. If you receive this notice, what happens if you just ignore it and say, I don't want to deal with that now?
So this is something that's really important, and a lot of people unfortunately they maybe miss an opportunity, because one of the ways to avoid a court case, an eviction case against them, is in this notice phase. Because if you do whatever the notice is asking, even if you think that it is wrong, you can avoid the court case. So if they're saying you owe money and you disagree, my suggestion, and one thing that you can do is, if you need to borrow money, apply for rental assistance, reach out to friends and family, pay what is debatably owed, and then fight it in small claims court. That is something that can be done, because fighting an eviction is something that is very difficult, and the favor is almost always in the landlord's favor. And unfortunately, if you do not respond to an eviction case, unfortunately, you also have the likelihood of missing a court date, of having a multitude of issues come up where you could have car issues, you could have issues with weather, you could have childcare issues and miss your court date. And if that were to happen, the landlord automatically could win. You could miss a filing date. And so many things are stacked against tenants in the unlawful detainer process, where trying to negotiate a favorable result when you first get that notice is really what is going to put you in a better position. So reach out to us or another legal aid organization or an attorney who handles unlawful detainers to try and get advice when you receive a notice, and it'll put you in a much better position early on.
Okay, great. Then one last question. Just in very general terms, then, what should you do? What is the next step? What should you do if you do receive an eviction notice?
So once you receive that notice, you know, don't wait, act immediately. So whether it's performing, so if that 3 day notice to pay, 3 day notice to cure, you need to do something, right? So waiting for the next action from your landlord is almost always going to put you in a less favorable position. So whether it's seeking legal advice, whether it is trying to make some form of payment, communicating with them in writing so that you have some documentation of your efforts, all of those things are going to put you in a better position.
Great. Well, thank you so much. Just to conclude, how can Inland County's legal services help?
We have a housing hotline that is staffed Monday through Thursday and some Fridays. We are staffed from 9 a.m. till 1 p.m. and then from 2 p.m. to 4 p.m. And we have paralegals who are supervised by attorneys who can answer your housing issues. And we also have what's called our Tenant Landlord Assistance Project, where if you already have an active unlawful detainer case and you're scheduled to appear for your trial, we can meet you at the courthouse and potentially assist you with your trial. Inland County's legal services represents tenants at all phases of their eviction case. Contact us and we'll see if we're able to assist you.
Thanks so much.
Thank you.